Good afternoon, and welcome to part 2 of our special presentation on updates to 5 C.F.R. 2638. I'm Patrick Shepard, and I'm very pleased to be joined again by Monica Ashar from OGE's General Counsel and Legal Policy Division. And today we're going to be focusing on updates to the portion of 2638 dealing with training requirements. So it's very timely, coming up towards the end of the year, and also very interesting. So we're looking forward to it. Should we just get into the slides, Monica?
Yeah, let's go ahead and get started.
Excellent, thank you.
So as Patrick was saying, today is the second half of a two-part series in which I discuss the revisions to 5 CFR Part 2638, the Executive Branch Ethics Program. So yesterday I provided an overview of the regulation and some of the highlights. And as Patrick said, today I'm going to be focusing on Subpart B, which deals with government ethics education. To reiterate, as I mentioned yesterday, the final rule amending this regulation was published in the Federal Register just last week, a little over a week ago, on November 2nd, and the changes go into effect on January 1st of 2017. So I'm going to bring up the overview slide again from yesterday's discussion. And I want to start again by noting that throughout this presentation, I'm going to be comparing the current version of Part 2638 to the revised or new version. And so while we're broadcasting today's presentation live, if you're watching a recording of the presentation and it's sometime after January 1st, the revised version of the regulation is going to be the one that's in effect. Again, today's presentation is going to focus on Subpart C. And the reason that we decided to do this as a separate presentation is that this is where you'll find the programmatic changes that are probably going to affect your ethics program on a day-to-day level the most out of all of the revisions. Some of the sections of Subpart C establish entirely new requirements, and agencies are going to need to establish new systems to implement them. Other sections improve upon existing requirements, and agencies are going to need to adapt their systems accordingly. However, I'd also like to point out at the same time that the revised regulation eliminates one of the provisions found in the current regulation. This provision is the formal requirement for agencies to develop annual training plans. As you know, and as you've probably experienced, these have consisted of rather detailed estimates and have required an effort that's, in many cases, disproportionately large compared to the benefits that these plans provided. And so you'll find that it has been eliminated from the revised regulation. Agencies, however, are still required to engage in reasonable planning efforts. We're just not going to prescribe the form that these efforts should take. So before I get into any of the specific types of training, I want to explain how the training framework will change. These framework changes pertain to, 1, how the training is delivered, and 2, the content that must be covered. And I want to start with how training is delivered. Under the current framework, as you know, OGE distinguishes between verbal and written training. Under the revised 2638, OGE instead distinguishes between live and interactive training. And when we say live training, we mean that the presenter personally communicates a substantial portion of the material at the same time as the trainee is receiving it, even if part of the training is pre-recorded or automated. This training could be done in person or in real time through the use of video or audio technology. So a typical example would be an agency ethics official personally delivering a presentation to a group of employees who are gathered in the same room. For employees who are located in a different part of the country, again, for example, the same presentation could also be delivered live via streaming video or telephone. And we also provide additional examples of live training in the revised regulation. So the next type of training under this new framework is interactive training. And when we say interactive training, we mean that the trainee must take an action with regard to the subject of the training. We recognize that many agencies will use some sort of computer-based technology to deliver the training. And so, for example, if the person being trained is using a computer program, they might be given a multiple choice question and have to select the correct answer. However, I want to point out that interactive training is not required to be high-tech training. For example, if an agency incorporates a written quiz into its training, and employees submit their responses for grading and receive personalized feedback, that would also satisfy the requirement for interactive training. Again, the key here is that the trainee needs to take an action with regard to the subject of the training. And finally, I also want to point out that training that satisfies the requirements for live training is also going to count for interactive training. So if you're training several employees and some are required to take interactive training and some are required to take live training, you could provide live training to the entire group and satisfy the formatting requirement.
So would it be fair here to say, Monica, that for live training, we're talking about the opportunity for people to interact in real time?
In real time.
And interactive training, we require people to interact with the material minimally.
Exactly.
Okay,
exactly.
That makes sense.
So the second major difference in framework is the required content. So under the current 2638, whenever you conduct annual training, agencies have to include at least a review of the principles, the standards, any agency supplemental standards, the conflict of interest statutes, and the contact information for certain ethics officials. And having done this myself at an agency, I know that it's a lot of content to adequately cover in a relatively short time. With the revised 2638, OGE wanted to create greater flexibility for agency ethics officials to tailor the content of the training to best meet the needs of their employees. And so under the new 2638, the requirement is that the training presentation focus on government ethics laws and regulations that the DAO deems appropriate for the employees participating in the training. At the same time, the presentation must address concepts related to the following 4 subjects. These are financial conflicts of interest, impartiality, misuse of position, and gifts. As we said in the preamble to the proposed rule, OGE is providing the DAO with broad discretion to determine how much of the training to devote to each of these 4 topic areas. After covering these 4 required topic areas, an agency's training may focus on other government ethics topics that the DAO deems relevant to the audience being trained.
I think it might be good to remind folks that these aren't just new requirements. We're also providing support to the community to meet these requirements. And if you weren't able to join us last month for our broadcast announcing some new ethics training materials, you might want to check that out. It's available on the YouTube channel at youtube.com/OGE Institute.
Now, I want to provide an example of what this might look like. So suppose an ethics official is conducting an hour-long ethics training, and many of the employees being trained in this particular audience are published authors. So the ethics official could spend the first 15 minutes addressing concepts related to financial conflicts of interest, impartiality, misuse of position, and gifts. That is the 4 required topic areas. And then the ethics official could spend the next 15 minutes covering restrictions on compensation for teaching, speaking, and writing. Again, our audience has a lot of published authors, and that would be the first 30 minutes of the ethics training. The ethics official could then spend 20 minutes discussing hypothetical examples related to the work of the agency, and 10 minutes answering questions. And so that's an example of something that would meet the new formatting requirement.
I think that's really good, Monica, because it allows flexibility for agencies to make the training relevant to the mission of the agency and the work that they do. And having that sort of temporal flexibility, I think, will be a big benefit to folks.
Exactly. Now, with those framework changes in mind, I'm now going to compare the current and revised versions of the types of training that you're already conducting. So in other words, the initial ethics orientation and annual ethics training. And I'm going to start with initial ethics training. So the current 2638 specifies that the initial ethics orientation be done as written training, although many agencies do more than that. Under the revised 2638, we specify that the training be interactive for the vast majority of new employees. And remember that with interactive training, we mean that the trainee must take an action with regard to the subject of the training. There is one exception, and I'm going to get to that in a moment. However, I'd also like to note that if you're at an agency that already exceeds the written training requirement under the current regulation, it's possible that your training might already comply with the new formatting requirement.
So when I was at an agency, Monica, we provided a 1-hour ethics briefing as part of our new employee onboarding.
Yes.
And that was a live in-person interactive session.
Right.
So we could continue to do that and we'd be fine.
Exactly. Moving on to the content of the presentation, again, under the current 2638, there is no presentation that's required. However, there are certain written materials that need to be provided. Under the revised 2638, again, there has to be some type of interactive presentation. This could be done by computer if the agency chooses, but it doesn't have to be. And the presentation has to cover the 4 key areas that I mentioned earlier: financial conflicts of interest, impartiality, misuse of position, and gifts. As I said, the DAO is free to choose the focus of the presentation, as well as any other ethics topics that should be included. In addition to completing the presentation, the employee needs to receive certain written materials. The materials themselves can be provided, or the ethics official could instead provide written instructions on how to access them. And you'll notice that these are very similar to the materials required to be provided under the current regulation.
This might be a good place to remind folks that we have created updated versions of these materials that you guys can customize and distribute either in print version or electronically to your employees. So if you're looking at the written materials requirement, you're saying, maybe this would be a good opportunity to refresh our approach. We have created some of those tools and we would really encourage you to use them.
Now, regarding the deadline for completing initial ethics training, we currently specify that this must occur within 90 days. Under the revised 2638, we specify that it has to occur within 3 months. And this change from 90 days to 3 months was intentional, even though they do roughly cover the same time period. What this does is that changing the deadline to 3 months allows agencies to offer initial ethics training 4 times per year and meet the regulatory requirement. On the other hand, 4 90-day periods fall slightly short of 1 full year. And now there are a couple of exceptions that I'd like to highlight. And the first pertains to the interactive requirement. And we say that non-supervisory positions below GS8 may be excluded from the requirement to receive interactive training. This would be done upon a written determination from the DAO when 3 criteria are met. So first, the duties of the position do not create a substantial likelihood that conflicts of interest will arise. Second, the position is not a confidential filing position. And third, the employee must still receive the required written materials within 3 months of appointment. The second exception relates to the deadline for special government employees who are reasonably expected to serve for no more than 60 days in a calendar year on a board, commission, or committee. For these SGEs, the agency may provide initial ethics training at any time before or at the beginning of the employee's first meeting of the board, the commission, or committee. Next, I'd like to discuss some of the key features of annual ethics training, starting with the requirements for public financial disclosure filers. Currently, as you know, all public filers are required to receive verbal training every year, which means that even if training is delivered electronically, agencies are still required to have a qualified instructor on hand during and immediately after the training. Under the revised 2638, however, not all public filers would be required to receive training in the same format. And here we distinguish among 3 categories of public filers. The first category consists of officials whose pay is set at levels 1 or 2 of the executive schedule. These are going to be your highest level PAS. They're required to complete 1 hour of live training every year. There is a very limited exception, which is that interactive training can be substituted in a particular year when a matter of vital national interest intervenes. The second category consists primarily of other presidentially appointed Senate-confirmed officials who are stationed in the U.S. These officials would be required to receive live training once every 2 years and interactive training in the alternate years. The final category consists of all other public filers, such as your Schedule Cs, Senior Executive Service, and so forth. They would be required to receive interactive training every year. Again, I want to really reiterate here that agencies are free to use live training in place of interactive training if they so choose. So if you're currently providing live training to all of your public filers on an annual basis, and you want to continue that practice, you're certainly encouraged to do so. Regarding the content of the presentation, under the current reg, agencies are required to provide at least a review of the principles, the standards, and so forth. However, written materials are not required. Under the revised 2638, the focus again is determined by the DAO, but remember those 4 key concepts must be addressed. Additionally, the individuals being trained would be required to receive certain written materials or written instructions for accessing them.
And again, we have created a model set of written materials that would meet this requirement. It has a place for you to customize, to add information about your supplemental regulations and your contact information. And you can find that under the Education tab on oge.gov. The title of the book is A Supplement to Annual Ethics Training.
And then finally, the deadline for completing the annual ethics training is still the end of the calendar year. Next, I'm going to discuss the annual training for confidential filers and certain other employees, such as contracting officers and other employees designated by the head of the agency. So under the current regulation, these employees are required to receive verbal training once every 3 years, with written training provided in the other 2 years. Under the revised 2638, employees would generally be required to receive interactive training, although there is an exception for certain short-term SGEs and officers in the uniformed services. The current content requirements are the same regardless of whether the employees receive verbal or written training in a particular year. Again, they need to receive at least a review of the principles, standards, and so forth. Under the revised 2638, again, the focus is determined by the DAO, but the 4 key concepts must be addressed. And again, financial conflicts of interest, impartiality, misuse of position, and gifts. In addition, the employees being trained have to receive certain written materials or written instructions for accessing them. And again, the deadline for completing the training is still the end of the calendar year. Having discussed the changes to the existing requirements, I'm now going to move on to some new requirements. The first of these pertains to new presidentially appointed Senate-confirmed officials. Specifically, it would generally require that agencies provide an ethics briefing to each new PAS. This briefing takes place in addition to the initial ethics training, although the two can be combined as long as the requirements of both are met. The initial ethics briefing has to be conducted live, and it must occur after confirmation, but not later than 15 days after appointment. If the briefing is for a special government employee who is expected to serve no more than 60 days on a board, commission, or committee in a calendar year, the briefing must be provided before that first meeting of the board, commission, or committee. And as far as tracking is concerned, the DAO has to maintain a record of the date of the ethics briefing for each current employee who has been required to complete one. At the ethics briefing, the ethics official has to do the following. First, discuss any new reportable financial interest the individual acquired and the potential for conflict. Second, the ethics official has to counsel the individual on the basic recusal requirement. Third, the ethics official has to explain the commitments that the individual made in his or her ethics agreement and ensure that the individual understands what is required for compliance. Fourth, they have to establish a process for recusal. So this might include a screening arrangement, for example. And then finally, the ethics official has to provide instructions and the deadline for completing initial ethics training, unless, of course, the training occurs before or during the briefing. And I want to stress that the purpose of this briefing is to ensure that PAS appointees will be able to comply immediately with applicable ethics requirements as they serve in their new positions. So it's very important that this be done timely.
I think this is an interesting new requirement, Monica, and I can see this sort of playing out in a couple of ways in agencies. For the folks who are going to receive their initial training not during the briefing, this might be a fairly short conversation reminding them of their obligations and how they can meet those. But ethics officials might also want to use this opportunity for those agencies that provide in-person one-on-one initial ethics orientation. They could also do that in combination with this.
Right. As long as the requirements of both are fulfilled.
Excellent.
So the next new requirement under the revised 2638 pertains to prospective employees. So this provision requires that new hires receive notice in their written offers of employment that they are subject to certain ethical obligations as employees. So having received this notice, each prospective new hire will be able to make a conscious choice to either become a contributing part of the agency's ethical culture or decline the job offer. And here, we anticipate that agencies will be able to take advantage of existing personnel systems because, of course, agencies are already preparing offer letters, and those offer letters are often largely boilerplate. So the language that would need to be included in this notice consists of, first, a statement regarding the agency's commitment to government ethics, notice that the individual will be subject to the standards of conduct and the criminal conflict of interest statutes, contact information for the agency's ethics office or an explanation of how to obtain additional information on ethics requirements, and then finally the notice of the time frame for completing initial ethics orientation. Again, these can generally be added to existing boilerplate language. However, for new employees that have to file a financial disclosure report, the notice will also need to contain a statement regarding the financial disclosure requirement and that the new entrant report needs to be filed within 30 days of appointment. And providing this notice in the offer letter should ultimately help filers to meet the 30-day filing deadline. And OGE recognizes that in many cases, it's going to be the agency's Office of Human Resources that are going to be sending out these notices. If this is indeed the case, HR is going to be required to coordinate with the DAO, follow the DAO's directions, and comply with any substantive and procedural requirements established by the DAO. With respect to the actual language of the notices, the DAO may choose to specify the language that the agency will use, or the DAO can approve, disapprove, or revise the language drafted by other agency officials.
I really like this new requirement, Monica. I've been involved with a number of agencies who have found themselves in a situation where someone has been brought on board who has significant potential conflicts and have to take significant steps to mitigate those remedial steps. And where employees haven't been notified of these possible requirements and that they'll be subject to these rules, that can come as an unpleasant surprise and create a less than ideal working relationship between the new employee and the ethics office. So here, I think if you've not found yourself in that situation before, this is really protecting you from an actual problem. And it can be a very unpleasant one to find yourself in. So I'm very excited about this, and I hope it saves people some grief.
The next new requirement pertains to new supervisors, and this would require that agencies notify newly appointed supervisors of their unique role in the agency's ethics program. As supervisors, these employees are going to have heightened personal responsibility for advancing government ethics. And so we say, for example, that supervisors are responsible when requested for assisting agency ethics officials in evaluating potential conflicts of interest. And OGE describes the role of supervisors in the revised 2638.103. This notice to new supervisors is done in writing, and it needs to contain the following. So first, the contact information for the agency's ethics office. Second, the text that addresses the government ethics responsibilities of supervisors, the principles of ethical conduct or a link to them, and any other information that the DAO deems necessary for new supervisors. Like the notices to new employees, the notices to new supervisors are meant to take advantage of existing personnel systems. Here, when we say new supervisors, we mean those new supervisors who are required to receive training pursuant to 5 CFR 412.202B, which is a regulation of the Office of Personnel Management. So this written notice could be provided either during that OPM mandated training or in the notice that these employees are subject to that training. Further, this notice has to be issued within 1 year of appointment, which intentionally corresponds to the time period established in the OPM regulation that I just mentioned. I'd also like to emphasize again that this is a written notification. Ethics officials are not being required to meet with new supervisors. And as with the notices to prospective employees, we recognize that in many cases, the agency's Office of Human Resources is going to be the office that sends out these notices. And if this is the case, HR is required to coordinate with the DAO, follow the DAO's directions, and comply with any substantive and procedural requirements established by the DAO. So next, I'd like to say a few words about tracking. For the annual training that is required under the revised regulation, employees must certify in writing that they completed the annual ethics training, complying with any procedures that the DAO establishes for confirmation. However, if the DAO or another presenter knows that a particular employee has completed the training, perhaps the training was delivered live and in person, that individual may record the employee's completion of the training instead. Additionally, if the employee is required to complete interactive training and the training is delivered through an automated system, the DAO may deem confirmation to have occurred if the system itself tracks completion automatically. Again, this tracking requirement applies to annual training required of your financial disclosure filers and certain others. Next, I'd like to say a few words about the tracking requirements for notices to prospective employees and new supervisors, as well as initial ethics training. Let me start by saying that you're not required to track every single notice that was sent out, nor every single initial ethics training that was conducted. Rather, the requirement is that the agency must establish written procedures for issuing such notices and conducting initial ethics training, which the DAO must review each year. Because of the nature of these notices and this training, we recognize that in some cases, offices that are not under the supervision of the DAO will nonetheless have been delegated responsibility for performing these duties. And in many cases, we anticipate that this is going to be the agency's Office of Human Resources, particularly for the notices to new employees and the notices to new supervisors. So there's an additional requirement for agencies with 1,000 or more employees when an office not under the DAO supervision issues ethics notices or administers initial ethics training. In this case, the office that performs these tasks must submit certain materials to the DAO by January 15th of each year. First, a written summary of procedures that have been established, and second, written confirmation that there is a reasonable basis for concluding that the procedures have been implemented. So this concludes my presentation. I just wanted to remind you that today's presentation, as well as yesterday's presentation on the overview of 2638, have been recorded and continue to be available online. And then additionally, one final reminder, the changes that I've discussed here today and that I discussed yesterday are going to go into effect on January 1st of 2017. And I also wanted to let you know that OGE today is issuing a legal advisory with a one-page chart that provides an overview of the requirements that I've discussed today for ethics training.
Well, thank you very much for joining us, Monica, and thanks to all of you for joining us for these two presentations. We hope you find them to be helpful, and we look forward to working with you to implement the changes required by the new regulation. It's really our goal to support the ethics community in meeting these challenges, both through providing you the written materials that we've already provided, some annual training scenarios that you can use either in person or adapt to whatever interactive format your agency uses. And we'll have some more resources coming out in the next few months around the area of initial ethics orientation. So it's really our goal to support you in these changes by providing the materials we are able to assist you in that role. And we look forward to working with you to improve ethics training across the government. So thanks again for joining us, Monica, and thank you all. And we look forward to seeing you next time.